My dissenting opinion responds to the particular legal points made by the Court. I would like to summarize here just a few general considerations. The Texas statute at issue here undeniably seeks to further the belief of its citizens that certain forms of sexual behavior are, as the Court says, quote, immoral and unacceptable. That is the same interest furthered by criminal laws against fornication, bigamy, adultery, adult incest, bestiality, and obscenity. Bowers held that this was a legitimate state interest, preventing sexual behavior that the society believed immoral and unacceptable. The Court today reaches the opposite conclusion. It embraces instead Justice Stevens' declaration in his Bowers dissent that, quote, the fact that the governing majority in a state has traditionally viewed a particular practice as immoral is not a sufficient reason for upholding a law prohibiting the practice. Close quote. This effectively decrees the end of all morals legislation. One of the most revealing statements in today's opinion is the Court's warning that the criminalization of homosexual conduct is, quote, an invitation to subject homosexual persons to discrimination, both in the public and in the private spheres. It is clear from this that the Court has taken sides in the culture war, and in particular in that battle of the culture war that concerns whether there should be any moral opprobrium attached to homosexual conduct. For many Americans do not want persons who openly engage in homosexual conduct to be partners in their business, scoutmasters for their children, teachers in their children's schools, or boarders in their home. They view this as protecting themselves and their families against a lifestyle they believe to be immoral and destructive. The Court, however, views it as discrimination, which it is the function of our judgments to deter. So imbued is the Court with the law profession's anti-homosexual culture that it is seemingly unaware that the attitudes of that culture are not obviously mainstream, that in most states what the Court calls discrimination against those who engage in homosexual acts is perfectly legal, that proposals to ban such discrimination under Title VII have repeatedly been rejected by Congress, that in some cases such discrimination is mandated by federal statute, such as the federal statute mandating discharge from the armed forces of any service member who engages or intends to engage in homosexual acts, and that in some cases such discrimination is a constitutional right, as we have held with regard to the Boy Scouts of America. Let me be clear that I have nothing against homosexuals or any other group promoting their agenda through normal democratic means. Social perceptions of sexual and other morality change over time, and every group has the right to persuade its fellow citizens that its view of such matters is best. That homosexuals have achieved some success in that enterprise is attested to by the fact that Texas is one of the few remaining states that criminalize consensual homosexual acts. But persuading one's fellow citizens is one thing, and imposing one's views in absence of democratic majority will is something else. What Texas has chosen to do is well within the range of traditional democratic action, and its hand should not be stayed through the invention of a brand new constitutional right by a court that is impatient of democratic change. It is indeed true, as the Court's opinion says, that, quote, later generations can see that laws once thought necessary and proper in fact serve only to oppress. And when that happens, later generations can repeal those laws. But it is the premise of our system that those judgments are to be made by the people and not imposed by a governing caste that knows best. One of the benefits of leaving regulation of this matter to the people rather than to the courts is that the people, unlike judges, need not carry things to their logical conclusion. The people may feel, for example, that their disapproval of homosexual conduct is strong enough to disallow homosexual marriage, but not strong enough to criminalize private homosexual acts, and they can legislate accordingly. The court today pretends that it possesses a similar freedom of action, so that we need not fear judicial imposition of homosexual marriage, as has recently occurred in Canada. At the end of its opinion, the court says that the present case, quote, does not involve whether the government must give formal recognition to any relationship that homosexual persons may seek to enter, close quote. Do not believe it. Today's opinion dismantles the structure of constitutional law that has permitted a distinction to be made between heterosexual and homosexual unions. If moral disapprobation of homosexual conduct is, as the court says, quote, no legitimate state interest, close quote, and if, as the court says, casting aside all pretense at neutrality, quote, when sexuality finds overt expression in intimate conduct with another person, the conduct can be but one element in a personal bond that is more enduring, close quote, what justification could there possibly be for denying the benefits of marriage to homosexual couples exercising what the court, in today's opinion, calls, quote, the liberty protected by the Constitution? One can believe that this case does not involve the issue of homosexual marriage only if one thinks that principle and logic have nothing to do with the decisions of this court. Many will hope that, as the court comfortingly assures us, that is so.